This is the story of baby Lindy and all the times we've been there for her. We were there in the beginning and when it became official.
Baby, congratulations.
We were there for Mom every day. We were there when big sister-to-be did
There's
this.
like 3 beads. She's been...
It's 2.
It's 2 beads.
When Dad did this.
Cheers, madame.
And when this happened, we were there too. So here we are. Baby Lindy will be born in exactly 10 minutes. Which is why we've organized an ambulance.
Just breathe, Dad.
To help get them to the hospital on time. We were there for baby Lindy. And we will be there for you.
Our next speaker is Louis Kruger, who is going to be talking about fertility law and surrogacy. Louis is a qualified social worker, attorney, notary, and conveyancer. He holds a Bachelor of Arts, a Bachelor of Laws, and a Bachelor of Social Work degree, and runs a private legal and social work practice. Louis and his husband, Llewellyn, are proud parents of a daughter born through surrogacy, which fanned the flame of an existing passion for helping people, which saw Louis expand his successful property law practice into the field of fertility work and family law. Welcome, Louis, on stage. Thank you so much.
Thank you. All right, good afternoon, everyone. Thank you to the organizers again for allowing us to be here and to share some knowledge with you. There's quite a lot to talk about when it comes to fertility law and particularly surrogacy. So I'm going to give you a very brief outline. I know there will probably be a whole heap of questions. You're welcome to come chat to us at our stand. But if there's little Emma, she's also in the back doing quality control. So we have 2 types of surrogacy typically. The very traditional, or the one that we were most accustomed to, was where the surrogate's own eggs are fertilized. And the surrogate really is pretty much carrying genetically her own child. That is quite frowned upon, particularly in South African law, because of the genetic link, the biological link, which gives the mother automatic rights in terms of our Children's Act. What is much preferred and the most popular is what we call gestational surrogacy. And that's where commissioning parents or intended parents will provide eggs, fertilized eggs or embryos, and those will then be transferred into a surrogate. So the surrogate will then carry a child to term to which she is not genetically related. Right, so that is preferred, and it's because of that we're able to enter into our surrogate motherhood agreement, where the surrogate absolves herself from any rights and responsibilities in relation to the child that will be born. Right, so again, the commissioning parents are the ones that have what we call parental rights and responsibilities towards that child. They are the parents. On the birth certificate, it says parent A, parent B, and it's the commissioning parents, whether same-sex or otherwise, who are reflected on the birth certificate, and the gestational surrogate is not reflected anywhere, other than the initial court application papers. So when a surrogacy recommended, there are obviously a number of instances, primarily where there's a health condition preventing a woman from becoming pregnant or carrying a pregnancy full term. An example would be a really early diagnosis of uterine cancer resulting in a hysterectomy, for example, where there's a possibility of a high-risk pregnancy, again due to health complications, and where infertility, where it's proven that it's permanent and irreversible, has prevented the woman from becoming pregnant. Surrogacy, again, is recommended, obviously, in same-sex couples or single male parents who cannot otherwise have children. We did joke a bit about our own application. We went to court and they wanted to know why we wanted a surrogate. We said, well, you know, missing the bits. So the next question is, who can be a surrogate? And I think this is really important, is that you need to be able to know what the attributes of a surrogate are before you go out looking for one. I think that's really important to understand, because it's really heart-wrenching to speak to someone and convince someone and they're all keen and you bring them to the table and then for some reason they are eliminated from being eligible. So first and foremost, and I'm going to repeat this quite often, is that surrogacy in South Africa cannot be done for commercial or financial gain. It is purely altruistic. We're going to talk about the financial elements just now, but it is purely done for someone who's got a really, really good heart and wants to give someone else the gift of having a child. Cannot be financially motivated. They have to be domiciled in the Republic of South Africa, living in South Africa, based in South Africa, under the age of 40 for obvious health reasons, have a healthy and viable uterus, and really importantly, proof of at least one pregnancy and viable delivery. And they must have a biological child alive at the time of confirming the surrogate motherhood agreement. So let's talk about the remuneration, because that's what everyone always asks. So we don't do commercial surrogacy in South Africa, or surrogacy for pay, as I've termed it. And it's a criminal offense to engage in that. And it's quite strict, because the surrogate mother may not receive any payments in terms of the Children's Act other than costs directly related to the artificial insemination, the pregnancy, birth, confirmation of the surrogate motherhood agreement, professional costs such as your medical and legal expenses. That is it. We're going to chat now about some of the other costs that make up those categories, but they cannot be a gratuitous vehicle, property, lump sum, anything that could be perceived to be changing that whole landscape and arrangement from something altruistic and being done out of love to, for financial gain. So commissioning parents, I preferred the word intended parents, those who are hoping to be parents, but commissioning are the parents who engage with the surrogate, who provide the surrogate with the means to fall pregnant. So can be single, regardless of sexual orientation. There was a change in the law a few years ago which allowed that. Obviously heterosexual or same-sex couples. You have to, in all respects, be a suitable person to accept the challenge and obligations and rights of parenthood for that child that is to be conceived. Understand the legal consequences of that surrogate motherhood agreement that's going to be signed, and then obviously the rights that flow from our Children's Act as a result of having a child. Quite importantly, in South Africa, the gametes, so either the egg or sperm, of at least one of the commissioning parents must be used in the conception. And the reason for that is, otherwise, if we allow people to use a donated egg and a donated sperm, they could be creating children to which they are not related in any way, shape, or form. And we have a very, very good adoption process to do exactly that. Where a commissioning parent or the surrogate mother is involved, married in a permanent life partnership, that partner, husband, must consent to the agreement before the court will allow it. Okay, so we have had some issues where surrogate mothers are perhaps estranged from their husbands, but they are still legally married, and we need to get that consent. and again, be domiciled in South Africa. Really important. We cannot, unfortunately, assist people who do not live in South Africa with surrogacy. Right, so what does the process look like? And again, the journey for everyone is different. For some people, it's completely smooth sailing. For others, there are a few stumbling blocks. But we suggest that you start your consultation with a fertility law specialist or an attorney that deals with surrogacy applications. They're going to help you and guide you so that you avoid expending any unnecessary money, and also just send you in the right direction and tell you immediately from the outset what kind of arrangements might already be a no-go area. Then the most difficult that we find in this field of work is finding a suitable surrogate. It's unfortunately not as simple as the egg doning process where you've got a beautiful catalog and you can pick the attributes and personality and availability of the person. It is quite often self-sourced. Many of the fertility clinics have women who have previously been a surrogate connect with them and say, if you have a patient who needs someone, here I am, I'm putting my hand up. But you can imagine that they get kind of snatched up almost immediately as they put their hands up. So put it out there. I think it's a bold step. If you need to put it on your social media or start sharing it with close friends, or it does happen when you put yourself out there. Then once you've identified the surrogate, very importantly is to take that surrogate to the gynae for that initial assessment to make sure that she is in all medical respects a suitable candidate. So what we're trying to do is we're trying to limit you spending vast amounts of money on various parts of the process only for certain things to cause elimination of that person from the process. Then there is additional screening. We're going to talk about that in more detail now. But at that point, once the gynae gives the all okay and the blood tests and everything that needs to be done has come back and all clear, then we start looking at things like police clearance, psychological evaluations, etc. Once all of that is in place, your chosen attorney will then use all of those. Those are all supporting documents, reports from the gynecologist, confirmation of blood test results such as HIV statuses. Again, we can work around it. There are ways. Couples who have HIV have been helped a number of times, actually, every day really. There are just additional hoops to have to jump through. We need to explain any risks that are involved in the process. And then that agreement, once it's signed by all the parties, is referred to the High Court, where the High Court will confirm the order. What is super, super, super important is that no fertility work, as it were, should commence until the High Court has approved that court order. We can't just, on the assumption that it's going to be approved and everyone got A+ on their report cards and, beautiful health results. We can't assume that it's automatically going to be approved, and we can't take any steps that show that we're kind of disregarding the court process. And the reason why our courts have become so sensitive about surrogacy applications is because, unfortunately, there are individuals around the world who have used surrogacy as a means for human trafficking. So because of that, the judges are almost very nervous to grant these applications because they need to be completely convinced that this is purely altruistic, personal, and there is no other means for the applicants to have a family. Right, so we have our surrogate mother, our commissioning parents who enter into this surrogate motherhood agreement. And what's interesting for those, and we get asked this quite often, is it's heard in chambers to protect the identity of the parties. The application to the court is done directly to the judge. Any meetings are held in the judge's chambers, which are their beautiful offices behind the courtroom. And quite often, the commissioning parents do not even appear before the judge. your attorney and advocate will go on the day when it's set down with all the paperwork, present it to the judge, answer any questions, do what needs to be done, and all being well, your order will be granted on the same day because the judge would have already read all the papers leading up to that meeting. So what is in this agreement? And I've just put some complete basics down, but it is what we call a preconception agreement. And South Africa is different there to the rest of the world. In other countries, you engage with the surrogate's pregnant, the baby is born, and then you start talking logistics. And at that point, the surrogate might say to you, sorry, I'm not kind of relinquishing the child to you. I've changed my mind. In South Africa, we bypass all of that. We're ahead of most other countries in the world, surprisingly, is that we do all of this before anyone has done any kind of fertility treatment. The rights and obligations of the parties. What are the parents going to do for the surrogate? What are the surrogate's obligations? Okay, there's often a question about this monthly allowance or a stipend. I don't know what's the most correct terminology, not to offend anyone, but there is a small gratuitous payment monthly to the surrogate. Around 4,000 to 6,000 is the kind of indicated amount, and that's for them to cover just basic, additional toiletries that they might need throughout the process, maybe clothes, maternity wear, additional, supplements and vitamins that you've seen on display here. Travel costs, anything that has increased, that's to cover that. They then also need to be put on a medical aid, and I can tell you from our own experience, it's the best thing ever. Get them on a really good medical aid, get them on early, that waiting period is over, they will cover majority of the costs, including the delivery. And then life and disability insurance for the surrogate, that's really a safeguard for the family. Particularly, we know that the surrogate does have a living child. And if anything were to go wrong during this surrogacy agreement or the delivery, that there is some protection for any family members that are left behind. Lifestyle concerns such as sexual behavior, drugs, alcohol, prescription medication, etc., all of that needs to be dealt with in that agreement. The idea is not to control the surrogate or to kind of, micromanage them, but we need to put the expectations out there. We are not going to start smoking, we're not going to go clubbing, we're not going to drug, we're not going to do anything and be a really good person and, stay at home and eat your salad. We have all these supporting affidavits, the psychological evaluations, the medical reports, the financial records, the SAPS clearance, everything that your attorney needs to convince that judge that you are the most suitable candidates will be obtained from you, and that's often where the cost kind of increases, and you'll see I can't really give you an exact cost for each of the categories because I don't know how many gynae visits you're going to need. I don't know how many meetings we're going to have. I don't know just how complicated your situation may be. But what is nice is what we get at the end of this is what we call a declaratory order, where the court has declared that this is how it is. And one of those declarators that the court makes is it says, from before this child is conceived, these are the parents. There's no confusion at any point before there's even an embryo created. These are the parents of the child. That court order authorizes the fertility clinic to commence with the IVF process. Having said that, there's no reason why you can't have eggs, retrieved so long and put on ice. There's no reason why the sperm can't be frozen and put on ice, but nothing could be fertilized until such time as this agreement is made available. There's also an instruction in that court order to Home Affairs to register the resulting child that is born from this. And it stipulates who the parents are that must be reflected on that birth certificate. I know everyone's seen the horror stories on Carte Blanche, but over time there's been so many surrogacy applications over time now that even Home Affairs has managed to come to grips with it. From the time the application is filed at court until it's heard and the judges makes their decision, typically post-COVID, we're looking at around 3 to 4 months. What makes it expensive? It's all high court. Okay, we don't work through the children's court in our, local courts where delays are kind of months to years in some instances. Okay, so what does it cost? Because that's really what everyone generally wants to know. And I've broken it down into categories, not to give you the amounts, but for you to consider that these are where the costs will come from. Fertility law specialists, so your consultations, drafting of that high court application, briefing of the advocate to move that application to be there on the day and get it past the judge. That's one aspect of the costs. Then your fertility clinic and related costs to the actual initial examination, the donation, if there is any, if you're not doing anonymous. Obviously, if you're going anonymous or through one of the donation clinics, their costs need to be factored in. Retrieval of eggs, if it's obviously going to be your own. And then all the IVF, all the costs related to creating those embryos, genetic testing that you choose to do afterwards. Whatever additional documents we need for court, additional psychological evaluations, know that you as the commissioning parents and the surrogate will be evaluated. It's not strenuous. It's really a very open morning discussion with a chat. We saw Mandy, and from that, they are going to just ensure that the court can be satisfied that you are doing this for the right reasons. There are no psychological disorders or concerns that need to be kept in mind. Obviously, then police clearance. Why? Because of that fear of human trafficking, any history of domestic violence, drug and alcohol abuse, and really just reckless living is what we need to prove to the court is actually not at risk here. And if someone has, during high school year had a drunk driving incident, we'll just have to explain to the judge that, they have reformed. Any blood tests or other medical tests, again, depending on your unique situation, if you've got a genetic disorder or a condition that needs to be explained to the judge, just to kind of paint an accurate picture. What's super, super important is that we don't leave out anything and that we don't mislead our courts. That's one way to get your application thrown out and never be approved again. Surrogates cost, obviously the medical expenses we've spoken about at the gynae, the medical aid, the insurance, the monthly allowance, and then there is also a caution of loss of earnings. And that could be if your surrogate is employed currently, and yes, she may be able to, have a period of maternity leave, but what does that maternity leave look like? Does she then, what happens to the shortfall in her income during the period that she's on leave? Also, should there be any complications with the pregnancy and she's unable to go to work and that affects her ability to earn, then that may be placed at your feet too. So that's just kind of the very broad outline of surrogacy. If you have any questions, you're welcome to ask them now or come and chat to us. My details are on screen. You are welcome to grab a business card too. If you have any questions over the next few days, weeks, or months, reach out to us. We're happy to refer you to some of our colleagues who can help you at various stages of your journey to parenthood through surrogacy. Thank you.
Thank you, Louis. Thank you for coming through and talking to us yesterday and today and being here with your stand. If you want to speak to Louis, his stand is down there on the right-hand side. Does anybody have any questions? No? Sure? Oh, Hillary.
Louis, you mentioned in terms of motherhood agreement, how does it get monitored of the lifestyle behavior of the surrogate once she's pregnant?
So that is why choosing the right surrogate is so incredibly important. The agreement sets out parameters, and obviously if there's a breach of that agreement, that could lead to either the commissioning parents wanting to cancel the agreement. But it's not like buying a house or a car and there's a breach provision and we can start imposing penalties and withholding money. It's not the purpose of the agreement is to regulate more so the expectations of the parties, the rights and obligations, and it is unfortunately one of those situations where if the surrogate is not towing the line and it is not beneficial to the pregnancy or it's detrimental, that the commissioning parents at a certain point need to decide, are we going to continue with this or are we not? We can't drag the surrogate in front of the judge, for a talking to. That's not the place for it. It is frustrating. I think one of our biggest fears, we always joked and said we were going to move our surrogate into the spare room. And I was going to cook to make sure it was a completely balanced meal every day and, have air purifiers the house through. But it is unfortunately one of the reasons why choosing the surrogate and having those initial kind of face-to-face meetings and chats and screening and psychological evaluations and all the steps that we do to try and minimize the risk of something going wrong.
And then also, if the surrogate is pregnant, what does the parents feel is their control over the surrogate? Because they are paying her for all this, and how are boundaries set for that?
I think, like with everything in life, boundaries set in advance are probably better than boundaries trying to be imposed at a later date. So I would almost be inclined, if there's a concern, to suggest that the agreement be elaborated on, that there maybe almost be like a rules and regs section to it, maybe more detailed than that which, and there you have the result of 18 months of waiting. Okay, go. Yay! Gonna get her there? Yeah. What you got? What you cooks? Cool. She's gonna cry. I'll keep her.
She will cry.
Yeah.
Daddy's girl.
From the payment side, from the parents, commissioning parents side, is this handled through trust accounts and through the attorneys, the payments going forward, and what would be the deposit to get this started?
So it's typically done directly between the commissioning parents and the surrogate, just to kind of speed up the process. I think if you're concerned about what you don't want, and that's why we kind of introduce that monthly allowance, because you don't want to get a phone call every kind of third day to go, I need Panado, I need, sanitary pads, I need to run to the doctor. And what we found really useful was putting the surrogate on a good medical aid and said to her, if there's any concern, phone us once you've been to the doctor. Like, don't wait for us. Get in the car and go. If there's a concern, go. We sort it out when we need to. You don't need to be involved, obviously, at every single step. But I just think that involving the attorney in that payment facilitation process is going to increase your cost. Unfortunately, attorneys sell time. But I don't think it's necessary if, from the outset, you've got the good medical aid, that monthly allowance is sufficient to cover what would ordinarily be required.
Okay, one more? Or two more? Crisis?
Hi, Louis. Just two, I'm here?
Yeah.
Two questions. So the agreement, how many attempts does it allow for in terms of how many IVF attempts? Because with probabilities the first attempt may not be successful? And how long is the agreement in place for? In other words, imagine super fast, first attempt, you have a pregnancy. Can you then say 3 months later, let's go for a second? Does the agreement allow for that?
That's a super quick pregnancy too. But the agreement must be exercised, we call it exercised or perfected, within a period of 18 months from being granted. So you've got 18 months from when that court order is granted to achieve your pregnancy, not to have the child born, but to achieve your pregnancy. And again, I think it's usually limited by costs rather than kind of agreement. How many cycles can someone realistically afford, and at what point do you go, maybe this is not going to work and this is not the right surrogate, or there's a complication. But typically you've got an 18-month window period in conjunction with your doctor and your surrogate to achieve that pregnancy. Obviously, you need to be reasonable. We can't subject the surrogate to monthly embryo transfers if the doctor doesn't think that that's actually going to increase the chances. So I think be led by your medical team, but know that if in 18 months you haven't achieved pregnancy, you would need to go back to court to ask them for an extension of that period.
One more question.
When does the agreement end, and are there activities dictated like breastfeeding and stuff like that after pregnancy?
Okay, so the agreements typically end 2 to 3 months post-delivery. So we suggest always that the surrogate be kept on that life insurance policy and medical aid for 2 to 3 months post-delivery. And we never really understood why, because everything's textbook. And then we were very fortunate after Emma was born, our surrogate got blood clots in the lung, just completely unexplained, whether it was as a result of the cesarean or not. Nobody knows. It was a week later, but thank goodness. Again, she knew, get in the car, get to hospital, get it sorted. And we then actually kept her on an additional month or two after what we had agreed. Obviously, the agreement is just, there. But you can kind of do a bit more than that if you need to. And we did more simply because we had some complications post-delivery. So that answers your first question, and your second one was the? So again, ideally we don't want that. We don't want to encourage any interaction between the surrogate and the child once born. So in hospital on the day, what happens is, obviously if it's natural or cesarean, is that you will take your child, the commissioning parents will take the child to the maternity ward, and the surrogate is booked into either a private ward or the surgical ward in the hospital, not in the same kind of area, general area even usually, as where you would be with a child. They recover so much quicker. They're up on their feet. They're not having to wake up and breastfeed. What you can do, obviously, and it can be a request, is to ask them to express colostrum, which you can then, give to the baby with their bottle. I just think from a psychological point of view, it's probably better to just draw the line in the sand as early in the process as you can.